The Latino Policy Forum works to improve education outcomes, advocate for affordable housing, promote just immigration policies, and strengthen community leadership. My name is Fanny Lopez Benitez. Today, I will share information about the housing protections and resources available for immigrant tenants in Illinois. By law, in Illinois, everyone has basic housing rights. I would like to highlight 5 of them. First, everyone has the right to live in a safe and reasonably maintained home. Everyone has a right to ask for repairs to the rental unit. Everyone has a right to communicate with government agencies, elected officials, and news media. Everyone has the right to join a tenants organization or union. And finally, everyone has a right to testify in court about the state of the rental unit. Many immigrant tenants have the assumption that they do not have housing rights. However, they do have a number of protections available to them. First, immigrant tenants must know that it is illegal for landlords to ask them to provide additional fees or documentation due to their perceived national origin. If landlords ask about immigration status, they must ask all applicants, regardless of their immigration status or national origin. Immigration status is not a protected class under the fair housing laws. However, national origin is protected. Some immigrant tenants might experience discrimination based on immigration status that is also connected to their national origin, and they might be able to receive protection under the fair housing laws. If a prospective tenant brings a translator or interpreter, the landlords must agree to work with the translator or interpreter. And finally, landlords should make sure that their tenants understand the lease. They should provide the lease in alternate formats. For example, they could provide a written lease in Spanish to ensure that Spanish-speaking tenants understand the terms of the lease. Immigrant tenants should know that lockouts are always illegal, regardless of immigration status. If you are a victim of an illegal lockout, please call an attorney or trusted housing organization. We provide a list at the end of this presentation. It is recommended that you have an ID showing your address to make it easier for you to prove that you live at the location where you experienced the illegal lockout. There might be times when an immigrant tenant has to call or interact with the police. We understand that many immigrants, especially those who are undocumented, might be afraid to call the police due to lack of trust or expected negative experiences. If an undocumented tenant must call the police, lawyers recommend the following. Please stay calm. Don't run, argue, resist, or obstruct the officer, even if you believe your rights are being violated. Keep your hands where police can see them. You do not have to consent to a search of yourself or your belongings. You do not have to answer questions about where you were born, whether you are a U.S. citizen, or how you entered the country. Anything you tell an officer can later be used against you in immigration court. Please don't lie or produce any false documents. Don't sign anything without speaking with a lawyer first. It is also important for immigrant tenants to know that eviction courts might have interpreter services available. For example, at the eviction court in Chicago's Daly Center, people can request an interpreter when they do the check-in with the clerk. If an interpreter is not available, you are not forced to continue with your case. You can request an extension until an interpreter is available. We also know that many immigrants are losing employment or income due to the COVID-19 pandemic. Many immigrant tenants did not receive the stimulus checks or other government support, and it is becoming difficult to afford their rent payments. Many immigrants are afraid to apply for emergency rental assistance programs because they are not sure if receiving rental support will trigger the public charge rule when they apply for a green card. Please know that as long as the assistance you receive is for an emergency and is a one-time payment, you should not have issues when you adjust your immigration status. If you are still unsure, please contact an immigration lawyer before you apply for housing assistance programs. You can also qualify for an eviction or utility moratorium regardless of your immigration status. And finally, there are many fair housing agencies that provide support for tenants, and they provide that support regardless of immigration status. Fair housing agencies should not ask about immigration status when they do intakes. Please don't be afraid to request support when needed. There is a housing law that provides protection specifically for immigrant tenants in Illinois. It's called the Immigrant Tenant Protection Act. This law went into effect in August of 2019. The law says that landlords cannot threaten or evict tenants because of their immigration status. ITPA protects tenants in 4 ways. First, your landlord may not threaten to call ICE, increase your rent, evict you, or shut off your utilities because you are exercising your rights. ITPA protects people of any immigration status who are currently renting. It also protects everyone living with the tenants, not just the people named on the lease. And it protects tenants with verbal lease agreements, not just written agreements. What can you do if your landlord threatens or evicts you because of your immigration status? We recommend that you contact an attorney right away. You can call MALDEF at 312-427-0701. They have lawyers who are familiar with ITPA violation cases. If you win a lawsuit against your landlord, you could win money to pay for any damages that happen, an additional $2,000 for each incident, and money to pay for your lawyer. Please know that you do not need to disclose your immigration status in order to report an ITPA violation or obtain legal support. Some people who are not immigrants might still be victims of an ITPA violation. Some landlords might assume that a tenant is undocumented based on stereotypes. The reality is that not all people of color are immigrants, and not all immigrants are undocumented. You do not have to be undocumented to receive protection under ITPA. The Immigrant Tenant Protection Act does not cover people applying for new housing. It only covers violations that occurred in the place where tenants are renting now or in previous homes as long as a violation occurred as of August 2019. It does not cover federally funded housing that requires landlords to check immigration status. And it doesn't prohibit landlords from asking for information necessary for credit checks before renting a unit. Tenants should know that they must continue paying rent until they move. Here's a list of organizations that provide legal housing support to undocumented tenants. We know that sometimes legal providers are not able to provide legal support to the undocumented if they receive federal funds, but this is a list that has confirmed that they provide support to the undocumented. If you have any questions or need additional information, please contact me at flopezbenitez@latinopolicyforum.org or call at 312-376-1766 extension 231. You can also access our COVID-19 Housing Resource Guide in this link to obtain more updates on housing policy and resources. Thank you for listening.